Carl Jarvis is a former U.S. naval officer and an alumnus of the U.S. Navy Nuclear Propulsion Program, where you served on the aircraft carrier USS Nimitz. And a graduate, this is long and technical. This guy is very, very smart, knows a great deal about the Constitution. It is on the back of your agenda, but the important thing is this man believes in the Constitution, has studied it, has solutions to the things that concern us that we have talked about in here, and is not only, doesn't just hold that knowledge in his head, but is going to share with you some solutions that we should consider and discuss. We're not just about knowing about these things, we're about taking some action. And you can see with what he's done with his kids, his very little kids, that taking action and training people early about what's great about this country is what he puts into practice every single day. So with that, please welcome Carl Jarvis.
Before we get started, I should mention that Joe the Garbage Man's grandma is actually right there, the one that was mentioned in the... go ahead and raise your hand. So it's quite an honor to be speaking to you all on Constitution Day. It's actually sort of a dream for someone that lives and breathes the Constitution. And I guess before we get to weightier matters, I also want to mention that my son was in the Vacation Liberty camp that you all had this summer. So I had to kind of, hopefully that was a surprise for you, Julie. Okay. Anyway, let's see. That's the rest of my family, and then on to business. Okay, so in the 20 minutes that I have, these are the two questions that we're going to talk about. Is the Supreme Court destroying our republic, and if so, what can be done about it? And what I want to do, rather than delve right into the nitty-gritty of the talk, is kind of start off at a high level, because I think to appreciate, certainly even for me to appreciate the details that I'm going to share with you, it helps to sort of start at more of a philosophical level about what our Constitution is really about. So with that in mind, I want to share with you first a little bit about how I embarked on this project, which I've been working on for several years now, basically with the support of my wife. So right out of high school, I joined the Navy, and it was when I took the oath of office to support and defend the Constitution that I got my first glimpse at the true greatness of our Constitution. And I remember thinking how remarkable it was that we were swearing an oath of allegiance to a military, not to a military commander or political leader, like you read about in Roman or English history. We were swearing our allegiance to an idea. And it was, that occurred to me at the time, but it was a few more years before I really engaged in any kind of serious study. And what happened was, a few years later in college, a friend of mine shared with me a story about a German mathematician named Kurt Gödel, who had figured out how the US Constitution could be made into a tyranny. There's a little story about that I don't have time to get into. But anyway, this was really what prompted my first serious study into the Constitution, because I was trying to figure out this riddle. And it was several years later when I happened to see a documentary about Woodrow Wilson, and it mentioned a book that he had written. And I remembered that this book had been mentioned in a history class that I'd taken. So I went out, and this was after I'd already read a few things and I was interested, but I went out and I got a copy of the book and I read it. And reading that book is really what sort of sent me down the rabbit hole of really wanting to figure out everything that's happened in this country in the last 100 years. Because it sort of opened my eyes to what was done, how it was done, and sort of the underlying philosophy that led to all these changes, just a few of which I'll be sharing with you tonight. So if you look at where our Constitution comes from, it really began with Aristotle. Aristotle was the first person who really started to ask, what would the best Constitution look like? And 2,000 years later, you could argue, his initial inquiry culminated in the formation of our own Constitution. Now, if you contrast what Aristotle was trying to do with what Plato was trying to do, you see huge differences. Where Aristotle sought the best form of government, Plato's quest was for the best leader, which he called the philosopher king. So these were two very different projects right from the start, and their assumptions and their conclusions are critically important to us today. Fundamentally, Aristotle assumed the people to be capable of governing themselves, while Plato assumed the people to be in need of a leader. Aristotle wanted to know how the people could govern themselves, i.e. the best way. Plato wanted to know how the people could be deceived into accepting the rule of a self-anointed elite. Aristotle's theory was realistic, practical, and rooted in a number of historical examples. Plato's theory was a utopian theory of a republic that wasn't really a republic, in which was really a thinly veiled apology for the kind of totalitarianism that we've seen in the last 100 years. So the dichotomy between Aristotle and Plato and the type of political philosophies that they espouse runs through Western history. You can find it expressed in a number of ways. Rule of law versus the will of men, republicanism versus monarchism, popular sovereignty versus the divine right of kings, constitutionalism versus totalitarianism, and we could go on. There was a core belief that led Aristotle and Plato each down their separate paths. Aristotle believed in institutions and placed his faith in institutions. Plato believed in leaders and placed his faith in leaders. This difference not only informed their theories, but it sheds a powerful light on many things that people have had to say since that time, up to and including the op-ed pages of our newspapers today. But the difference between Aristotle and Plato can be reduced to even more basic terms. Aristotle sought to reckon with and account for the weaknesses of human nature. Plato basically ignored human nature with his vision of a virtuous, all-wise, and benevolent leader who would fix all the ills of society. So when you lay these two philosophies side by side, just the way I've outlined, it's pretty clear which philosophy would tend to perpetuate liberty and preserve republican institutions. It's also pretty obvious which philosophy informed the creation of our Constitution. But it was maybe not so obvious during the critical period when our Constitution was being formed. If you go back and look at the writings of the founding era, you find all sorts of comments equating republicanism with virtue, in which lament the moral depravity of the people and their leaders at the time. In fact, John Adams, there's a great quote by John Adams to the effect that he saw pervasive corruption and greed and wondered in 1776 whether republicanism was doomed due to a lack of virtue in the people and in their political leaders. So there's, of course, a big problem with taking virtue to be a prerequisite for republicanism. Depraved acts, corruption, greed, and abuse of power can't be eradicated because they're inherent to human nature. Adams himself, over the next several years, after despairing whether moral enlightenment would ever come, and doubting whether even education could fix the situation, began focusing on political institutions. He theorized about institutions in several books he wrote, and he wrote a good portion of the original Massachusetts state constitution, later a model for the US Constitution. And so here's the lesson we learned from Adams. By thinking in institutional terms, we define the conditions for liberty in a way that makes those conditions possible to achieve within the limits of human nature. By thinking in terms of re-education and moral regeneration, we define the conditions for liberty in a way that makes liberty inherently impossible to maintain at any point after the fall of Adam. The real question hit upon by the framers of the Constitution is how political institutions can be used to channel and tame the passions inherent in human nature. In fact, in the framers' view, this was the entire reason to have a Constitution. There's Madison's famous quote from Federalist 51, "If men were angels, no government would be necessary. If angels were to govern men, we wouldn't need checks and balances." There are a lot of people today that seem to think that we can get rid of checks and balances and that we can trust the inherent goodness of leaders. Obviously, that's not what the framers of the Constitution believed. Meanwhile, if the framers insisted upon defining the problem of liberty in pervasive moral or educational terms, they never would have solved the problem. On the other hand, look at what was achieved through the formation of the Constitution. This is a quote by George Washington in 1791. And some of you may be familiar with this quote if you've read The 5,000-Year Leap. He mentions this quote in the introduction. The country enjoys a scene of prosperity under the new government that hardly could have been hoped for, which 3 years ago would have been a species of madness to have foretold. So the question is, did the people's morals change in that space of time? Did the lusts and passions of their leaders change? That's pretty doubtful. I believe that Washington's statement is a testimony to the transformative and regenerative power of political institutions. But you can still ask the question, if we have a constitution, why does everything seem to be going off the tracks? Why don't we follow it? And the answer lies in the fact that if you look at the Constitution, there are a number of points in it where it points to political institutions that it does not itself provide. And so the specific thing we're going to talk about tonight is with respect to the Supreme Court and the evolution and development of the federal judiciary. So the Supreme Court is really a case study in this idea that you need to think about more than just the written Constitution if you want to understand what's happened to this country, especially in the last 100 years. Because when you read Article 3, you don't find a whole lot there, really. Most of it is delegating power to Congress to form the judicial system. So today, at a time when federal judicial nominations are more contentious than ever, because everyone feels the need to have the quote-unquote right justices and judges selected because they wield so much power, we've come to focus so much on personalities and the issue of judicial activism of the justices that we totally ignore the institutional context which gives them so much power in the first place. So we could talk for a very long time about the history of the federal judiciary, but I really just want to hit on three main points. And we're going to kind of talk about this from the perspective of the Judiciary Act of 1789 and how the system was originally set up, you know, compare and contrast with how it works today. So really, the idea with the Judiciary Act of 1789 was to form a balance between state and federal power. That was the explicit intention of the folks that, not only the folks that wrote Article 3 of the Constitution, but also the people that wrote the Judiciary Act, a lot of whom were the same people. So even with, you know, within the Judiciary Act, you can go pretty deep, but the 3 points we're going to talk about tonight are the jurisdiction of the federal courts, the circuit riding requirement that Supreme Court justices were required back then, and the appellate jurisdiction of the Supreme Court. And I just want to say, actually I forgot to advance my slides. Let's see, where are we? Oh, okay. So there we are, Supreme Court, and we're up to the Judiciary Act of 1789. Sorry about that. So when you start getting into these things, they're really pretty esoteric. I mean, you could go to the, you know, really, really deep into it. But with these 3 points, so first, the jurisdiction of the federal courts. So under the Judiciary Act of 1789, the state courts had a significant role in trying cases arising under federal law. This was not an oversight, it was deliberate on the part of the framers of the act. This divvying up a jurisdiction between state and federal courts was intended to keep the federal courts in check in an effort to keep the federal government and federal power in check. Today, due to jurisdictional changes, really that started back in the 1830s with the South Carolina nullification crisis, and then a bunch of changes that continued to be made after that. The default now is for cases arising under federal law to be tried in federal court. I mean, that's just a standard operating procedure. It was not at the time when the federal judiciary was first formed. Okay, second, you had the circuit riding requirement. And you know, a lot of people take this to be sort of an antiquated holdover from maybe the English courts. But it was actually deliberate. And the idea was to keep the justices close to local circumstances and to keep them from retreating into this sort of ivory tower of legal abstractions. Incidentally, it also forced a geographical representation on the court, on the Supreme Court that is, because each justice on the court had to be drawn from a specific circuit. Those circuits were geographically defined, and so you had someone on the court that represented every area of the country, which you do not have today. Okay, third and most important, it was with regard to the appellate jurisdiction of the Supreme Court. And this is, again, a fairly esoteric issue, but this is probably the most important factor in giving the Supreme Court the power that it has today. And specifically, under the Judiciary Act of 1789, just comparing and contrasting with today, appeals to the Supreme Court were a matter of right governed by law. In other words, and this is very important to understand how the Supreme Court works today, the Supreme Court had no discretion whatsoever to decide which cases it would hear on appeal. So through these provisions, the intent, as I mentioned earlier, was to balance state and federal power. Now, it's worth delving into this issue of the appellate jurisdiction a little bit further. And I'm going to advance the slide here. This is a cartoon from the turn of the century showing how overworked the Supreme Court was at the time. Because they had all these cases that they were required to hear, and so sad, but they didn't have this discretionary jurisdiction to decide which cases they would hear. And of course, this was the argument that was made. But if you look at what was actually happening, the Supreme Court even today makes rulings all the time that unilaterally expand its own jurisdiction. So you could certainly make the case that, if the Supreme Court didn't want to work as hard back then, they could have just said, well, we don't have the power to hear this case. Now, if you look at where we are today, the power of the Supreme Court has become completely unanchored. And there's really no norms whatsoever to constrain the power of the court in deciding which cases it hears. And this is really what has allowed the court to usurp the powers reserved to the people and their representatives, particularly with respect to the lawmaking process. And if you look at what the court does and how it does it when it renders a landmark ruling under the guise of interpreting the Constitution, it's a completely arbitrary process from beginning to end. So they receive petition to certiorari. Four of them agree that they're going to hear the case, and there's some other things that go into it, but basically they use this process to carefully select which cases they want to decide on the basis of where they want to influence policy. That's really what makes the Supreme Court a policy-making body today, in point of fact, aside from the fiction that they're a legal tribunal. So the question is, are we subject to law? Are we subject to rule of law? Are we subject to the will of 9 Supreme Court justices? And I'll let you all decide, based on the evidence I've presented, whether the Supreme Court is in fact destroying our republic or not. And the point of offering those 3 points isn't, I'm not up here trying to say that we need to reform the system along those lines. It's really more to get people thinking about how it's changed and how those changes really work against a lot of things that I think a lot of folks believe in. So there's a lot more that could be said about that, but I want to go back to Aristotle for a moment. And so I mentioned a moment ago, when you read the Constitution, you find these points where it references political institutions outside. And among those are, you can look at appointing presidential electors, redistricting law, committee system in Congress, the nominating process. And so all these institutions have evolved a great deal over history, even though the Constitution has stayed the same. And so to see the real importance of that evolution, I think you have to kind of go back to Aristotle. And it's kind of interesting. He never finished writing the book where he talks about the best constitution. It's sort of parts of it are incomplete and so forth. And it was actually supposed to be the second part of a treatise on ethics, which did get completed. And if you read Aristotle's Ethics, you find a very interesting observation, which is on the screen here. Virtue is the mean state between two vices, one in excess, the other in defect. And I believe that if Aristotle had brought his inquiry into the best form of government to completion, he would have applied this notion of a mean state explicitly to political institutions, whereas it was really sort of implicit in the theory that he came up with. And if you look at how these political institutions outside the Constitution have evolved over our entire history, it's pretty clear that when you take the whole thing into account, today we're at an extreme in every area. 100 years ago, we were more in that mean state, and we've gotten away from that. And I believe that that's what's tearing our Republican form of government to pieces. I'm going to go ahead and wrap it up here, just with a few final thoughts. So the greatest question we face today is the greatest question of any age. It's the question of whether the people are capable of governing themselves or not. When we talk about our problems in terms of the virtue of leaders or the morals of the people, we cannot solve our problems by thinking about them that way. The only thing we can really affect within the context of human nature is our institutions. It was Sidney Algernon who said, "To depend on the will of any man is slavery." And in so doing, he declared an end to the kind of thinking which had enslaved mankind for millennia. The framers took our Constitution, in what Algernon said, one step further. They decided that people are capable of governing themselves, and they gave us the institutions to do so. Today, our Constitution remains intact, but the institutions which surround it and support it are faltering. The good news is that the problem is not indefinite, but specific enough that a small number of determined people may change the future of the country. So with that, I guess I want to, we'll open it up for Q&A, but I guess first I want to let you all know that I am getting ready to publish a book, and so if anyone would like to be notified via email, and there's some opt-outs here, if you don't want a book notice, but you want a newsletter notice, or so it's name, email, and then the other thing that I wanted to offer to the group as well is if anyone, and this will of course depend on everyone's interest, but if anyone is interested in more of a seminar format to go more in depth with some of these ideas, I'd be happy to do that. I was talking to Julie about maybe doing it as a fundraiser for the PAC, but whether or not that makes sense, I guess it'll depend on people's level of interest. And with that, I guess I'll stop talking here and we'll open it up for questions. Well, I mean, 100 years ago, I think it was probably all Protestant. So the question was about the religious composition of the Supreme Court. I think you said 6 Catholics and 3 Jewish folks, and that's all changed. I don't know. Well, I guess Brandeis was the first Jewish person who was appointed. That was back in 1916. First Catholic. I'm not sure, but I was not aware that it was all Catholics and all. I don't know anything about that and how that specifically has changed. It probably does make sense for the Supreme Court. One thing that would do, along the lines of their discretion, these people basically wait to resign until they can find an appropriate successor. So it would eliminate that discretion and you'd have more of a rule of law governing that. As far as term limits for elected officials, I actually don't think that they're a good idea. And that could be, for the Supreme Court, yeah. I'd probably say something like 14 years, somewhere in that neighborhood. I mean, it should be longer than the Senate. But I guess the point that I was making is that that would require a constitutional amendment. There's a lot of things that are statutory that people don't even think about that are really the real issue. I mean, all the stuff that I mentioned with circuit riding and jurisdictional issues, that's all statutory stuff. I mean, that's stuff that Congress could pass a law and change tomorrow if they wanted to. So I know that Mark Levin has a bunch of proposals about different things, and I guess the view that I've developed is that a lot of these problems are statutory and they're almost like state, not quite state, but more like well, not quite local, but state law with respect to how a lot of these things work, and so people don't think about them in the context of the U.S. Constitution because it's like, well, state law doesn't have anything to do with that. Did you?
I was going to mention the Levine's book, which is suggestions, term limits for the Supreme Court. Also,
Right.
I have questions on the jurisdiction of the court. Is that not set by Congress?
It is set by Congress.
Congress could limit it?
Oh yeah.
Where do they get the authority of extending their jurisdictions without express
The
approval from Congress?
So it really boils down to this issue of discretionary jurisdiction and this writ of certiorari that they've taken, and basically, the Supreme Court is not required to hear any cases anymore. Since 1988, that's been the law. And there may be, I may be butchering that a little bit, there might be a handful of cases every year that they're required to hear still, but most of them are just selected, and that's definitely statutory all the way.
If I made the problem, that's looking at the Band-Aid at the other end. The problem is the federal government is so large and has its hands in so many things under federal law.
Right.
That everything in our life has a way of getting up to the Supreme Court because the federal government is involved in everything.
Yeah, and
government, then
right.
have so many things to decide.
And if you go back and look at what was done, around the turn of the century, a big part of that, and it was very deliberate. I mean, if you go back and look at the Federal Convention and what they were saying about why they wanted U.S. senators to be elected by the state legislatures, they wanted to give the states a quote-unquote power of self-defense. I mean, that's literally quoting from the Federal Convention. So this idea that you're going to have direct elections and it's not going to change the nature or the degree of centralization in the government is a lie. I mean, it absolutely did affect that. And there was other stuff too, especially with the nominating process, which if we went into that, it would take all night, and I don't want to do that to y'all.
Well, I've had the pleasure of hearing you before at another meeting. And could you just say briefly, I think what you mentioned is that we're operating as an oligarchy now, actually, in fact.
Right.
And then you mentioned czars and executive power relative to executive orders that have been issued.
Right.
The executive power, and specifically the one executive order which was... Right,
yeah, and I do have some thoughts on that. So you're talking about this executive order 13603, and it was, so I looked at this. It was signed by Obama back in March 2012, and Jim Powell wrote an article in Forbes about it, Obama's plan to seize control of our economy and our lives, basically asserting totalitarian control. You can find that article online, but there's differing opinions about this. I actually looked at it, and I looked at its predecessor. Very little changed between this one and the one that Bill Clinton signed in like 1994. So nothing new, and so some people say, well, this is no big deal, nothing changed. I mean, I guess that depends on your perspective, right? Because if you read it, it does actually give the federal government de facto, it doesn't say this, but it gives the federal government de facto power to seize, transportation, communications infrastructure, water supplies, food supplies, energy supplies. So, I mean, it's pretty nasty stuff. I guess if you wanted to talk about the larger issue of where does that power for the president to make law at the stroke of a pen, just the 30-second version of that is that in the last 100 years, we've developed a permanent bureaucracy, at the federal level, which we did not have before that. And a big reason has to do with the fact that prior to 1912, presidents had unlimited power to unfettered removal power over government employees. And then in 1912, there was this Lloyd-La Follette Act that they passed. And one of the things it did was it allowed federal government employees to unionize, but another thing it did is it made it so that they could only be removed for cause, which means they really can't be removed at all. So then you have this problem where people join the government, but they never leave, and you end up with a situation where you have a permanent bureaucracy and endless paperwork, endless regulations, and presidents who have the power to make law with the stroke of a pen, which they did not before. I mean, executive orders were nothing prior to, say, 1910. They were used, but they were so minor that it was administrative. So that's definitely not the case today. I don't want to cut into the main meeting.
No, this is the
Okay.
This is a big.
Okay.
Are you saying that the czars and all the agencies that have been established, the head of those agencies are appointed by the president, correct?
Right, yeah.
But he can unappoint them. So how is that different than the
So what I'm talking about though is below the level of appointees. These are more like regular government. I mean, you used to have like a spoil system. You read about that with Andrew Jackson and so forth. And that's how the system worked from 1828 to really 1912-ish. I mean, you had a civil service reform, but we won't go too deep into it. But the real change was with that removal power. And again, it applied not to like cabinet level appointees or people that were getting confirmed by the Senate. It applied to ordinary civil servants, basically, is who I'm talking about.
Okay, but how would it be affected if the Congress decided to get rid of agencies? What happens to all those people that work for us, eh? Is that complicated?
I mean, I guess they would get fired, right?
Well,
The whole thing is that now it's very hard. What's that?
sounds like we can't fire them. Would you have to find a job somewhere?
Oh. I mean, I think that there are exceptions if an agency gets defunded, but the whole idea of, they used to come in and basically clean house and reappoint. Reappoint is the wrong word. They used to rehire a bunch of people. And so they don't do that anymore. So the bureaucracy is less accountable to the electoral process and so forth. And it's become a law unto itself, really. And that's why it has to do with the removal power.
Getting back to your point about the U.S. Supreme Court, since the U.S. Supreme Court is not an elected body, and they have the power of judicial review from the Martin versus Madison case, they've had that for almost over 200 years. You had mentioned earlier something about a quasi-effective term limit on Supreme Court justices, longer than the Senate, but not a lifetime appointment. How would you keep the Supreme Court from getting restacked under an elected system, how the House of Representatives or even the Senate can get stacked every election cycle?
Well, I think if you had something like a 14 or maybe 20-year term, I don't know what the exact number would be, but it would end up being weighted, and it's kind of weighted now, but it's not. There's imperfections with it, but it would end up being weighted to whoever happened to be in political office for the last 14 or 20 years. So in that sense, it would actually be more accountable in a way to the electoral process, sort of indirectly, if that makes sense. I don't know if that answers your question, though.
It just seems that having term limits on the Supreme Court, it almost seems like it would open the door for more
for packing?
For more packing and more political corruption with this election cycle.
It's not anything that I would say, hey, this is our #1 priority.
Right.
There's so much statutory stuff. Like I said, it's that's the place to start, I think.
In your opinion, where is the constitutionality of the government mandating that everybody purchase Obamacare products, and in light of the fact that nobody knows exactly what it's going to do, everyone who voted for it voted without knowing what it was, and those who promoted it fraudulently. Where's the constitutionality in forcing people to buy it?
It's an abomination, if you want one word for it. I mean, there is no
Then
constitution.
why are people just being quiet and not putting up a fight? I mean, a big
I think
fight.
it has to do with the nature of incumbency, if you will, and the fact that these folks get elected and then you can't ever get them out of office.
But there are a lot of Republicans who just are kind of being quiet about it, and they're afraid of shutting down the government, and they're not voting anything to defend it. I think, in my own opinion, I think that the Tea Party should look at these people, and if they're just going off and going to let it go on, just act like they voted for it in the first place anyhow, and do everything out of office.
I would agree with that. You know, I guess maybe one thing I would propose is even if y'all don't take me up on the seminar, maybe you could have me back to talk about the nominating process, because that is a topic that's near and dear to my heart. In fact, in my opinion, the nominating process is really what is, you know, destroying our country today, if you want to put it in so many words. And it was really a pretty tremendous coup that they pulled off during the Progressive era when they had the direct primary system basically supplant the party convention system. Because what it did is it totally took ordinary people out of the nominating process and informed folks like the people in this room. And so the whole thing is decided now by money, and it's decided by who can push the biggest emotional hot button, and it's decided by name recognition. And at least 2 out of 3 of those issues give a huge advantage to incumbents, and the direct primary is actually the main reason why we can't get these people out of office. If you were to distill it down to one thing, and again, I could go on and on and on about this, but if you look at before 1912 and after 1912, just with respect to the presidency, you see a huge change in the incumbency advantage from before and after that point in time when the direct primary really became prevalent.
Now, I don't know if you know the answer to this, but I was listening to an interview with the attorney for the Beckett Foundation, who took the Hobby Lobby case, and in the district court they won, so he was very positive about where that was going. But in the interview he said within 2 years there will be a litigated effort, and it will go to the Supreme Court, and the result will be same-sex marriage will be allowed in every state. You have to be able to, so it will be a federal, non-federal mandate, and so you're talking, so obviously he's looking ahead
Right.
and saying what's been decided by the state, somehow they'll litigate it, how they'll do it, I don't know. But, I mean, do you know anything about that kind of process and how they would?
Well, you have a whole cottage industry of groups, and I mean, I'm not going to dignify them by naming any names, but they basically file lawsuits for a living and get donations for it, and they basically use the court system as, you know, a quasi-legislative system. I mean, that's been happening now, and I think a lot of it does tie back into some of the jurisdictional issues that we talked about, and, you know, why does the Supreme Court have the power to decide? Because kind of think about this as just as a thought experiment. If the Supreme Court had to hear mandatory appeals every time X issue, you know, so they make a ruling along those lines which nationalizes some issue in a way that the states object to, right? And you have state objections to it, but the Supreme Court has to hear the appeal every time the states, you know, do something naughty under that ruling. it has to go all the way up to the Supreme Court. Well, they would be flooded with so many cases that they wouldn't even be able to deal with any of it. So that's the nature of the problem, and that's really how these groups are able to use the courts as a legislative process. I mean, that's what ends up happening. Okay, one more question.
Yeah, I've read or heard that there's something in the Constitution which gives the Congress the power of dictating non-review by the Supreme Court. In other words, they can tell the Supreme Court that they cannot review this law. And I don't know if I read it or heard it or whatever.
So there are people who've written entire books about that question. And so the question is, you're basically asking about, can Congress pass a law and say that the Supreme Court can't review such and such type of case?
Correct.
Yeah. So there's been a lot written about this, and a lot of the, I guess you'd say, academic folks will say that the Congress cannot pass those kind of laws. But the fact of the matter is, Congress is the one that gave the Supreme Court the power in the first place. So it really does not stand to reason that Congress can't go back and curtail that power. I mean, it's a completely nonsensical argument. You don't have to amend the Constitution to change stuff like that. You can alter the Supreme Court's jurisdiction and make those rulings unenforceable. That's just the way that...
Checks and balances as well.
Exactly. I mean, if you read Article 3, it gives, the specific thing you're asking about, in Article 3, it gives Congress the power to regulate the appellate jurisdiction of the Supreme Court. So that's the power that gives Congress the ability to do that. And I guess with that, we'll thank you all for having me. This was great.